I thank the honourable member for Bowman. The question is that this bill be now read a second time, and I call the honourable member for Perth.
Well, thank you, Mr Deputy Speaker. I was going to begin by complimenting the member for Bowman on an excellent speech. He did blot his copybook towards the end, but I think he gave a very a powerful and important explanation of the importance of TRIPS and the role that this legislation will play in ensuring that third world communities actually have access to the drugs that they need to deal with very severe conditions and to overcome some of this fundamental inequity that exists across the planet, where people that are most in need of medical assistance and advanced pharmaceuticals so often simply do not have access to those. So I want to compliment him, as I said, for really explaining that in very considerable detail. He did, however, blot his copybook somewhat towards the end because he misrepresented the case of who in fact first proposed this legislation. And the legislation in relation to TRIPS, as we all know now, did in fact first come before this Parliament in 2013, a piece of legislation promoted by the Labor government. But of course at that time, in keeping with the just say no approach of the then opposition, was actually objected to, was described as inadequate, incompetent legislation by the now fortunately now departed former member for Indi. But of course we now see this legislation brought back into this place, and of course it does have the support of the opposition. Now there was just a couple of matters that I wanted to raise here today, and that's one of the things that is not in the bill. There has been one entire area where there is a difference between the Labor bill and the bill now before the House, and that is, as my colleague earlier mentioned, is the removal of the Crown use provisions. And these are provisions that already exist within patent law that allow the Crown from time to time to be able to utilise patents for public purposes without necessarily obtaining the licence of the patent holder. They are required to pay compensation for that, so it is not something that will detract from the economic position of the patent holder, but in order to ensure that public good is not is protected by the patent law, and at the end of the day, patent law is a gift of the state to the private patent holders. We can go right back to the days of the woolen stockings that were the first subject of patent protection in the United Kingdom, in order to encourage the French merchants to come over and bring their worsted stockings to England. So it is very much a gift, and part of the Crown use provisions are a recognition that from time to time there is an important role for the state to be able to access those patents and to have that capacity to do so. Now, this has become, and you know, there hasn't in fact been all that much Crown use of patents in Australia, and I think we've found half a dozen instances where this has been invoked, two of whom have been contested. But I think this is going to be an issue now that will become increasingly important because of this issue of gene patenting. Now there is a great deal of concern in the community, and I guess amongst certain people, including the cancer survivors, a sense that the ability to be able to patent a gene mutation such as BRCA C and the BRCA mutations for breast cancer is really seen to be by many people as quite repugnant, and people find it very, very difficult. I'll just read an email I got received the other day from a Leslie Keegan. And Leslie says, I can't say how disgusted I am with Australian patent laws, which is in the process of allowing patenting of genes. It isn't about saving lives, this is about making money. It is happening in every genetic research sector, including the one close to my heart, the genetic heart research sector. And I have had the misfortune to have had contact with people within the genetic hearts research sector, and my opinion is, and has been for some while, there is something intrinsically wrong with the system. And I think we've seen the same from cancer survivors. Now, look, this is a very complex area, and I think in the 2004 report, and I think it was one of the first and most comprehensive reports into this whole issue of patenting of genetic material and whether or not we should allow it, the Law Reform Commission, certainly expressed that they were sympathetic to the concerns of the public about the capacity to do this, but they made the point that if this was something that in fact had been addressed in the 1980s, just as this development of the genetic sequencing, the capacity to do this detailed genetic sequencing was emerging, as the activity of private laboratories in this area was emerging, then it may well have been possible to do something. The point that they have made in the 2004 report and in the 2009 submissions to the Senate inquiry, and I think to the subsequent 2013 report, was really the genie, if I can say that, the genie is out of the box, and there are now so many tens of thousands of patents that have been granted in this area that indeed it would be difficult really to unwind that. So recognise the problem, but we have really gone too far down the track, in their view, to unwind this. So what they proposed instead was that we modernise and make more accessible these Crown use provisions. So those Crown use provisions were to be modified and strengthened so that in situations such as we have, if there were the situation, as there are people that are fearful is the case, where there are cases where this research has not been made available or the access to the genetic material has not been made available to allow treatment or further development of subsequent research to take place, if it is in fact blocking the development of realistic and affordable solutions for people who suffer from the genetic mutations, then indeed the Crown use provision would enable the government to override the exclusivity of the patent, ensure proper compensation. But nevertheless, it provides that level of protection. Now, unfortunately, the government of the day today has decided that it is not going to do that. It is not going to act in accordance with the recommendations of the Australian Law Reform Commission in this regard, and they are not going to allow those Crown use provisions to be strengthened and modernised so that they may indeed provide this fallback provision. I want to do one other item I just want to comment briefly on, and it is the plant breeders' rights. Now, the provisions in this the bill before us make it provide for a more accessible regime, to greater accessibility to courts for a more speedy resolution of disputes relating to plant breeders' rights. And of course, that's important. These can be very expensive processes. But if I can just make this observation, that I think there is a great future in genetic modification. I do understand concern in sectors of the community about GM, But I think basically, again, it's really science. It is progress. It can enable us to do extraordinary things, to take genes for drought resistance from plants in the African deserts, incorporate those into food crops, and ensure that we in fact can deal with some of the climate change provisions, the circumstances of climate change in a drying continent that we're facing here in Australia. So I think there's great potential for GM. But I think one of the really big risks that we face is the conduct of the companies that are owning those GM rights. And I don't think that we have got the legal regime here right. I think some of the really unfair treatment of people whose crops have been corrupted by the GM crops, who have been infiltrated by GM crops and who then find themselves on the receiving end of penalties, is really quite extraordinary. And I think until we really resolve that legal issue, until we've got a fairer regime for those farmers that are making the choice, as they should be able to make the choice, not to go down the GM path, their concern is twofold. One is their ability to be able to protect their product, but an even more profound concern is that if they are unwittingly the subject of an invasion by seed from GM plantations, that they themselves, and not only does it undermine their economic model, but they themselves can indeed become financially liable for having expropriated the stock and the genetic material of the seed company. Now that is just a completely untenable position, and I think that is one of the things that is standing in the way of there being a widespread exception, or a wider spread acceptance of GM crops. So I really do urge us. I know this is not the issue that is centrally dealt with here, but we are freeing up or making it easier to take action under plant breeders' rights, and I think part of the sequelae of that has to be to make sure that those rights are indeed fair and protect the interests of non-GM farmers as well. So we do support this legislation. We are particularly enthusiastic about the implementation of the TRIPS regime, and we're not an opposition that just says no as a matter of recourse, as is shown here by our support, notwithstanding the fact that an almost identical bill was opposed by the Conservatives when they were in government. So I am happy to support this bill and commend it to the House.